Great. Well, thank you so much for being here. We're going to be talking about intellectual property today. This is the Intellectual Property 101 Masterclass for AI entrepreneurs, and we'll dig in. So, why does this topic matter, especially for AI entrepreneurs? And I usually think about AI businesses in kind of two buckets. We have businesses that are seeking VC funding, looking for big exits. So, um, for those kind of VC-backed startups, their IP drives valuation. Whoever is purchasing you or venture capitalists who are going to invest in you, they want to know what your IP is like, because that is where a lot of the value for an AI business lives. And the other bucket is more of a kind of lifestyle family business that we see just explosion of these businesses, people getting into AI automations, building voice agents, and don't have necessarily the desire to scale into some kind of a unicorn company. And so for these businesses, still IP protects their income and protects their legacy. So it's an important topic for any business, but especially for a business in technology in the AI space. And today we're going to focus, I will try to be more kind of tactical and practical rather than just giving a legal lecture. And so a little bit about me, who am I? Why am I talking about this? My name is Tatyana Gray Etkin. I'm an attorney. But before I was an attorney, I went to college and got my undergraduate degree in computer science in 2002. And I actually worked as a software developer for a little bit for a Fortune 500 company. So I do have that technical background. I understand a lot of the tech, unlike a lot of the other attorneys that just didn't have that background, which is fine. So after I did that and worked in the software industry, I went to law school and graduated in 2006 in the top 10% of my class. I'm licensed in Utah and Idaho, so I'm a real attorney. I don't just play one on YouTube, and I see real clients. I have real clients. I have a law practice called Summit Legacy Law, and that is what we focus on is just custom legal work, traditional, bill by the hour type of stuff that I think everybody basically thinks attorneys do. And I am also a founder, just an entrepreneur, just like you guys. And I started this non-traditional legal business called businessattorney.ai. I'm still building it out. I'm still in the early stages of that. And my goal is to provide legal contract templates for AI entrepreneurs. And to have the boutique legal template space, because I see so many poorly generated templates out there, either generated by AI or come from places that are very generic. So I really want to focus on AI entrepreneurs. And on top of that, I love educating. I have a heart to educate people. And so I provide legal education. A lot of it is through master classes like this one. And I'm not sure if you guys came from LinkedIn, saw this on LinkedIn, or if you came from my school community called Legal Launchpad for AI entrepreneurs. But that is really if you're seeking more legal education and more, like I said, practical, tactical, I would invite you to join school and find our community Legal Launchpad and join us there. So that is a little bit about me on kind of the professional level. On the personal level, I'm a mom in a blended family. We have 5 kids, and you can see some of them are still pretty little. So life is busy. My life overflows with everything. So, and just moving on, a disclaimer, just have to do it that nothing in this masterclass is legal advice. Everything is general educational, and always consult an attorney for your specific situation. And why would you trust me? Why would you listen to me? I already kind of got into this a little bit. Unlike a lot of the old-fashioned attorneys, I don't just believe in speaking lawyer and charging huge retainers just to get started. And I believe in systems. I love systems and having a clear step-by-step system. Um, with that, I developed a legal protection system specifically because I saw so many AI entrepreneurs out there building, but on very shaky legal foundations. And a lot of the people are getting into the AI space. It's very, I guess, very hot right now, and not having a lot of experience in business and not having a lot of experience in legal, and just jumping in, which I love the passion, but then being burned by various legal issues. And so again, as a somebody who loves systems and having been in the legal industry for 20 years now, basically, I just see a lot of the hesitancy to go to lawyers, again, retainers, hourly billing, and just not even understanding. I've heard entrepreneurs just say they come to a website for a law firm and there are all of these practice areas, and the entrepreneur just doesn't even know where do I start, what do I need, where do I go. So really trying from that come up with a system. And so this is the system that I call it the legal protection system, but it is a holistic view of an AI business. And like anything, before we get anywhere, we need to know where we start. So I start with this legal audit, just to know where a business is, and then everything else. I try to break it into these five big pillars, and really organize it into entity and ownership, compliance and data, revenue monetization, team and operations, and intellectual property. And obviously, we're talking about the intellectual property piece of it today, focusing on that. But that is kind of how everything fits. And then different contracts and different issues, they fit into those five pillars. And even today, talking about intellectual property, we're going to be touching on all of the other parts because intellectual property touches everything with an AI business. So now, kind of having seen the bigger picture, we're going to zoom in on our IP specific part. And with IP, there are some very important building blocks. Again, this is intellectual property 101. This is not designed to be, in super depth. So we're gonna go high level. Again, this is an introduction, and I don't know what your level of experience is. It might be, you might be very familiar with this. I hope you still learn something new, or everything might be pretty new to you. And this is my first time doing this particular master class, so we'll see how it goes. I'm curious to hear questions and see from the field of what of the issues maybe that need to be added into this master class, and maybe some of the stuff needs to be subtracted to make it better. So with that, we're going to talk about some of the building blocks of intellectual property for a business. And there are really four big ones. There are more than that. Again, for this 101 level, we're going to focus on these four. Trademarks. And trademarks in general is kind of your brand identity. And we'll dig into each of these issues. So trademarks, copyrights deal with your creative works in your business. Patents really relate to your inventions, and trade secrets, your secret sauce, things that are confidential, that obviously secret, you want to keep them secret. Like I said, there's more. We're just going to focus on these four for today. I'm not sure why this is not moving. There you go. So we're going to dig into the trademarks first, and I think that is where a lot of the businesses really start. That is kind of natural because when you're talking about trademarks, you're really talking about the very beginning of your business. And as a mom with a baby, obviously one of the first things is we pick a name for the baby. So the same for your business. Like your business is your baby. So you usually start with picking a name for your business. And that is where trademark would come in. Picking the name for your business or for your brand is one of the first intellectual property issues that you're going to deal with, even if maybe you don't realize at the beginning. So trademarks protect names of your businesses, names of your products, your logos, your product brands. And when you're starting, you might only have one name, your business name, and your products are all within your business. So that might be pretty easy, but as your company grows, you might be adding on different brands and different products. And if you think of bigger companies, if you think of Apple, obviously the name is Apple, right? But they have different brands within that. They have the iPhone and the iPad and the iMac, right? So as your business grows, you can be adding on different names that you can trademark that you will be using in your business. Trademarks prevent lookalikes and copycats, which is obvious. And again, this is with the name as well as things like your logos, right? A lot of the companies that are bigger companies, of course, we learn to recognize them by their logos. We know Apple logo, we know Nike logo. We don't need to see the actual name spelled out. We know who the company is. So trademarks would protect your logos as well. And one of the kind of early on issues that I see with many business owners, not just in the AI space. Again, one of the first things you do, you came up with a name and you go get the domain, right? We run our name that we want to name our business against a domain, and we want to see if the .com or .ai is available. And sometimes people think, oh, I got this domain, so I'm good. But getting a domain name does not mean that you have a trademark on your business name or your brand name. So that is one of the early on issues that I see, and I just wanted to help clarify that. Domain not equals a trademark. And a great reason to have trademarks actually registered is that you would be able to do takedown notices, and we'll talk about it in detail in a couple more slides about these takedown notices, but that is your enforcement mechanism. If somebody's infringing on your trademarks, you can use these takedown notices to protect yourself. So that is kind of the basic overview of trademarks. Again, they cover anything written, word marks, or things like logo with your images. But what makes a good trademark? And we're talking specifically here about a name. Again, this is one of the first IP issues that a new business would deal with, is coming up with a name. And with names for trademark, there is this spectrum of distinctiveness. And the more distinctive your name is, the better, the more likely that you can get a trademark. And we call that the strongest, the most distinctive name, fanciful. And we'll have another slide where we have some examples of that, fanciful. Then the next kind of level is arbitrary, where there's a strong likelihood that you would get your trademark registered. The next one is suggestive names, which have good chance of being registered. And then descriptive names are kind of weak and pretty risky. And if you're using something generic, that's just not protectable for trademark purposes. So we'll look a little bit into these examples of this spectrum. Well, what is a fanciful name? When you're picking a name for your business, really, if you can come up with a fanciful name, that's the best, that's the strongest. Fanciful name is a completely invented word that has no meaning other than as your brand. And an example here, maybe you have an AI powered, again, this is an example. I don't know if there's a real business with that name out there or not. Naming your AI powered market research platform something like Quantilux. This is a word that is made up and has no dictionary definition, and that makes it inherently distinctive and highly protectable. So if you can come up with some kind of combination of, jumble two different words together, that would be the best. In my prior life, I'm also an inventor, and I invented at some point a firearm safety device, and specifically for firearms that women preferred. And so with that business name, I called it Shootessa. And so that was a fanciful name because I took the name of shoot and tried to make it feminine, this essa suffix. So that is an example from my own life of a fanciful name that would get the strongest trademark protection. Arbitrary gives you a strong chance of getting your name trademark, and arbitrary names are real words that have no logical connection to the AI service being offered. And one example would be, for example, Apple, right? Apple is arbitrary. We know what an apple is. It's a fruit, right? It has no connection to computers, but it was a strong brand name for Apple computers because again, it had no logical connection to the computers. An example here I came up with for AI businesses, it's like calling your AI platform that optimizes shipping logistics Oasis AI. We know what the word Oasis means, right? It's a real word, but it has nothing to do with AI. So that connection is arbitrary, and that makes it legally strong for a brand name. For suggestive, it's still a good chance that you can trademark a suggestive name, but that is a name that hints at a quality or benefit of the service, requiring some imagination to connect the two. An example here, branding an AI tool that helps developers find bugs in their code, and you can call it like Synapse AI, and we know that a synapse is this connection in the brain, so that can suggest some kind of connection and intelligent thought. Does not directly describe the function, and so it's still a good chance that it would be trademarkable. And now we get to the descriptive names that are weak and risky. A descriptive name is a name that directly describes the service, its function, or a key feature. Would be hard to trademark that. For example, naming your product AI Code Assistant. This name directly describes what the product is and does, and it's very difficult to get exclusive trademark rights for such a name unless you can prove it has acquired some kind of secondary meaning over time, which is a costly and lengthy process. From, again, my own personal kind of life, at some point when my son was born, I was really into making my own baby food for him, and I wanted to share what I was making. So I had this little business and I called it Baby Meal Plans. So that's a descriptive name. It describes exactly what that was, Baby Meal Plans. So that would be a very bad, weak, and risky way to try to trademark that, and I never did. So when you're naming something, think of that. We tend to, and I understand that we tend to use the descriptive names because we think it will make it easier for marketing purposes. My suggestion would be is if you can come up with a fanciful name, then your descriptive name can be, the second line, the tag, the slogan, something like that. And the last, which is not protectable at all, is a generic name. If you have a business dealing with AI, if you name it Machine Learning Inc., obviously that is so generic, you would get no trademark protection with that. So this is just, again, helping you to think about when you're starting your business or you're launching a new product, what to name it. So keep that in mind, so you can get a trademark on it. Again, trademark would protect you against other people that would infringe on your product. I want to touch on the trademark symbols because I've heard questions about those, and there's confusion with those. When can you use it? When can you not use it? And so I'm sure you've seen different businesses write their name and then they put TM or SM or this little R. So TM just stands for trademark, and it relates to a service. I'm sorry, for goods. Whoops. TM relates to goods that you sell, and SM, service mark, relates to services that you sell. So TM and SM you can use even if you haven't registered federally your trademark. You can just use it to basically alert others that you are claiming it as your own. You can have also state level trademarks, and mostly we talk about federal trademark registration, but there's state trademark registration as well. And if you intend to file for trademark and you're claiming the name or the logo as your trademarked IP, you can be using TM again for goods or SM for services. The little R can only be used if you got a federal trademark from USPTO, US Patent and Trademark Office. Has to be officially granted to you, and using the little R without an official registration is actually illegal. So you don't want to do that. If you really kind of want to put stake in the ground before you register with USPTO, you can use TM or SM. Okay? So that is kind of the trademarks, again, 101 level. There is way more to go into, and if any of you have, if you're thinking about filing a federal trademark, I would recommend, I will try to put the information out there. I would recommend that you schedule a strategy call with our office. We can help you filing your federal trademark, and we can get into the depth of it and discuss, your specific names and images. Do a preliminary search, and I would recommend that all of you, there are free searches out there that you can conduct. So conduct free searches. There are also paid searches that are more extensive, so that is an option as well. And I will try to have resources available on that after we finish this. If I can contact you guys and keep watching in our school community and on LinkedIn, I will post this with more resources. Like I said, this is my first time doing this masterclass, and that is kind of something that really would be great now is to, as I'm going through this, to add the resources. So let's move to copyrights. I spend a lot of the time here on trademarks because, like I said, I do think this is where a lot of the newer AI entrepreneurs, make mistakes and not going down the route of registering your trademarks early enough. The problem, of course, that if somebody else uses the same name or similar name and they registered before you do, you would have to rebrand. And rebranding is costly, lengthy, takes time away from what you need to be doing, which is, prospecting and serving your customers. So I would recommend, on top of everything else I said, that you really consider trademark earlier. And in the grand scheme of things, it is a protection that you can get relatively inexpensively. We will talk about some other protections, IP protections, that are quite expensive. But trademarking, I think, should be on the forefront of most AI entrepreneurs, and it is something that you should take care of as soon as really practical in your, in your business. So, with that said, off my soapbox, copyrights. Copyrights are a different IP, intellectual property. And here, I guess I'll backtrack. I never really taught intellectual property. It seems self-evident from the name, right? Intellectual. It comes from our head, from our intellect. Unlike real property, which obviously is, land, and personal property, which is stuff, things, right? But we can touch the land, we can put our feet on the land, we can touch our personal property, right? We can pick it up, we can take the steering wheel from our car. So we understand what property is, and also intellectual is the property. It's the stuff that comes out of our head. Basically, we invent it, we create it. Yeah, we can't touch it. So it's intangible until it's reduced into some kind of product, possibly, a book if it's physical product. And that's why there's such a wide range of intellectual property, and we give it the status of property. And that's why it can have protections under the law, just like your real property and personal property have protections under the law. So the next type of intellectual property is copyright. And copyright is, like it says, it's a right to copy something. Who has the right to copy something and who doesn't? So copyrights protects things like code and data sets, if we're talking specifically about AI space, but broadly it protects content. And content can be obviously writings that are reduced to books, writings that are reduced to blogs, writings that are reduced to website copy. And obviously code is self-explanatory, and data sets that you're operating on in your AI business. All that can be entitled to a copyright protection. With copyright, one of the biggest mistakes that I see with AI entrepreneurs, especially on the earlier side, this misconception that if you paid for something, that you own it and that you get copyright on that. I hear people misuse the whole work for hire doctrine. And there is this work for hire doctrine that if you hire somebody and as the employer, you direct them to create something for your business, that your business would automatically own that work. It is generally true with employer-employee relationship. It is generally not true with contractors, with independent contractors. And with most AI entrepreneurs, with most new businesses, when we're starting new businesses, we rely on contractors, independent contractors, not employees, for whatever reasons. We might not have enough work for a full-time employee to do, or even a part-time employee, and prefer to deal with contractors on, per project basis or hourly basis. So this is one of the biggest mistakes. Just because you have an independent contractor create a logo for you, or create social media posts for you, or write code, your developers that are independent contractors, because they're writing code for you, it doesn't automatically mean you own that. It is actually means they still own the code or any of the content that they create. And so just remember that work for hire does not generally apply to contractors. The solution to that is a very strong IP assignment language in your contract or after the fact as a standalone assignment agreement, plus your NDA, non-disclosure agreements as well. You want to make sure that you stay in control over people that are creating stuff for you. If it's, whatever you create is one thing, but whatever other people create for you, you have to be very careful. Again, we'll talk about the symbol, copyright symbol a little bit, and that's the C. We had the R for trademarks and C for copyright. And that symbol is a public notice that you're claiming ownership over a piece of creative work. And the copyright protection is automatic in the United States as soon as you create something original and reduce it into some kind of writing. Using the C symbol is highly recommended anyway, because it removes any doubt about who the owner is and when the work was created. And here I just want to make a distinction, because just having an idea is not enough. Like, we all have ideas. Your idea has to be reduced into some kind of product, a writing, a book, an article, a blog, a social media post. With code, you can think of whatever you want, whatever kind of software product you want, but the idea is not copyrightable until you actually have code written. And so I would recommend highly that whenever possible, you do use this little C symbol, and year of first publication, and then owner's name. You see it most often on people's websites, that you would have in the footer this copyright, and you would say year 2025 and owner's name. If you don't have an entity, if you're operating as a sole proprietor, it would be your personal name. However, I highly recommend that everybody has a legal entity for personal liability purposes, for protection. And I have another masterclass I did on business entities, and I will try to link it somewhere as well. So again, your individual name if you don't have an entity, or your entity's name if you do have an entity. There is a lot of kind of gray area right now with authorships of AI generated content. Who owns that? Is that the AI, or is that the human? Can you claim ownership and copyright over books or blogs or other content that AI generates for you? So the consensus is for right now that if something is entirely generated by AI based on your prompt without any creative input from a human, that cannot be copyrighted. And so the key factor here, that it has to be a product of human authorship. And the role of human input is that a human would provide significant creative direction that is reflected in the AI's output. And then the resulting work may be eligible for copyright protection. And here's an example, and I think of it as YouTube thumbnails. I personally work on my YouTube thumbnails, and this is where, to me, it's the best example. If I give a prompt to AI to generate a thumbnail and I describe it, and I use it as is, it is given to me, that would be entirely built by an AI system. However, what I usually do, I have AI generate certain elements in the thumbnail. I like to take my picture and feed it into AI and ask it to give me a different pose or a different facial expression. And then I would take that, and by hand, I would combine that picture. I would work on the title. I would work on the background. And so there is a lot of human creative direction in that way. And so I believe that in that case, I would be able to copyright the YouTube thumbnail, even though part of it was generated by AI, but I put so much of my creativity into it that it should be eligible for copyright. So if somebody decided to take my YouTube thumbnail in that case, I would be able to claim infringement. And we'll talk about takedown notices. Another big issue is training AI models with copyrighted data. So here, a major point is what happens if you use existing copyrighted materials, text, images, music, to train your AI models? And usually the AI businesses like to claim fair use doctrine, which we are allowed to use certain copyrighted material without permission for purposes such as criticism, commentary, and research. So that seems to be AI businesses claim usually. And then, of course, the content owner, the copyright owner, they usually claim that that is still infringement and that is unauthorized use of their work. And that AI companies or AI businesses profit from creative labor by just modifying it somehow and without compensation. And we've seen cases out there, some of the big cases. There's the Anthropic case where I believe that's the Anthropic case where we know that they've used a lot of the books that were pirated to feed into the model. And the court said that illegal inputs are illegal. Pirated inputs are illegal. There's also a case with, I believe it's Disney and Midjourney, where Midjourney can generate characters without any type of compensation. So we see more and more case law popping up in that regard. And so this is still an area that's developing. AI law is moving at a breakneck speed, and that's one of the reasons I like being in this field because it's keeping us on our toes as attorneys. There's constant learning, and I'm a lifetime learner. I love learning. But it obviously it creates a lot of moving parts for all of us on the legal side, on the business side. So this is just an area to constantly be aware of what are you using for inputs for any AI models that you're building for your clients and selling. And so now we'll get back to the takedown notices. What are takedown notices? Again, I talk to entrepreneurs that hear this term, but they don't quite understand what it is. So we'll briefly talk about it. The takedown notices are just formal requests to platforms to remove infringing content. So this is not the same as like a cease and desist that you would send to a private business or individual infringing on your content. These takedown notices are to platforms. And they're usually based on trademarks or copyrights. So for trademarks, it would be brand impersonation, or for copyrights, some kind of stolen code or content. There's specifically copyright related takedown notices under the DMCA, Digital Millennial Copyright Act. And these takedown notices work by going to the platforms, so like social media, Instagrams, YouTubes, hosts, like Bluehost, website hosts, marketplaces, it can be eBay, I don't know, Amazon probably would fall under a marketplace. And this notice goes to the platform. You would have to show how the infringement happened. So for example, with my YouTube thumbnail example, I could contact YouTube and send this takedown notice to YouTube because somebody's using my thumbnail on their video, and YouTube would do the work, right? So this is not directly to the person who's infringing. This is to the platform on which they're infringing. And platforms have a legal incentive to comply because obviously if there is infringement going on openly, the people won't come to the platform. So they're very motivated to keep that and enforce that. And quickly, I know we're running out of time almost, and here a case study that I wanted to just use an example. An Airtable contractor, I hope you guys know about what Airtable is. It's just software. It's kind of like Google spreadsheets on steroids or Excel on steroids. Very popular. You can build different automations into that. And so here's an example, a founder that has a product that sits on top of Airtable, has some automations in the Airtable. They have their Airtable base. that they are, selling successfully, but they need help. So they want to hire a freelancer to expand their Airtable base, improve it, add more features. And that's great, right? That's great. But if you go and hire a freelancer like that, again, a freelancer generally means independent contractor. Um, and again, you cannot rely on this work for hire. This is where the mistake happens. You're a freelancer, you're an independent contractor, 1099. The work for hire would not generally apply to them. If your agreement with them is done over some kind of DM string or Discord or whatever, Instagram DMs or even email, um, if you don't have an IP assignment, then the freelancer would own that expansion to your Airtable base. They would own it. So it's very important when you hire an independent contractor to actually have an independent contractor agreement. And this is where businessattorney.ai comes in. Like I said, I'm actively working and pushing that to get it out there for AI entrepreneurs to have great templates that specifically cater to AI entrepreneurs for independent contractor agreements. That's one of the 5 core templates that I'm really working hard to get out there. Make sure that there is a strong assignment clause from your freelancer to the owner, to you, to the entrepreneur, your business. The risk, if you don't have IP assignment, they still own the IP. The risk is that they would simply duplicate or copy it. They will copy your Airtable base, and whatever improvements they made, they'll go resell it. And even worse, they can poach your clients. So make sure to fix that. Make sure you have in your independent contractor agreement, there's assignment, IP assignment, that there's confidentiality, so they cannot go and disclose your, Airtable base, and that there's also non-solicitation provision that they cannot poach your clients, your customers, or your other contractors and people, your team. So that is, in a practical way, what needs to be done. And that is about it for copyright that we're going to touch on today. I cannot see any comments right now, in all honesty, but if you have any comments, if you would like to, in the future, for me to go deeper on any of these issues, or if you have specific questions, if you put them in the chat before we're done, I will make sure to get all of the questions so I can follow up on that. The third type of IP we're going to touch on today is patents. And patents protect inventions, algorithms, hardware. For AI businesses, it would be mostly some kind of algorithm, most likely. Invention is the important part of it. It has to be novel. That is one of the requirements to patent something. It has to be novel. Patents are expensive. You're probably looking at easily $10,000, $20,000. They're slow. You're looking at several years to prosecute your patent from start to end. But they're very valuable for defensibility of your business. They're very valuable asset of your business. So for most early stage AI founders, patents are probably not a priority. Trademarks, copyrights, that's why we talk about them first, are more where you need to focus your capital initially. And it's good to keep in mind that there is this option to patent, but it is, software, for example, is harder to patent than something, physical and novel invention, or, algorithms. So patents are not my big specialty. And, there are some really amazing patent attorneys out there, and they really focus on the patents. So that would be my recommendation, really, to, if you are getting to that space where you have some novel algorithm, then I can help you get in touch with a patent attorney, but really, patent attorney would be the way to go. And the last from our IP buckets is trade secrets. So we talked about trademarks, we talked about copyrights, we touched a little bit on the patents, and then the last one for today's discussion is trade secrets. And trade secrets are, as they are, your secret sauce. They protect your data sets, they protect your prompts, your workflows, your pricing models, but it is a secret. It is only protected if it is maintained as a secret. Some of the ways to protect your trade secrets is to have really strong NDAs, non-disclosure agreements, with your team and your co-founders, if you have co-founders or bring co-founders on board, and have access controls. Have very strong access controls. If you have a VA, your VA doesn't need to be in your code, right? So just thinking through that, um, and really remembering that you keep it secret. An example here is retail. For those of you who are doing voice AI, if you have a retail fine-tune model, that would be an example of your trade secret. So keep it secret. I know that there are a lot of AI entrepreneurs there with YouTube channels that put different like N8N workflows out there or share their prompts to educate others. And I think it is very noble and timely, and I love, like I said, I have a heart to educate. I applaud other AI entrepreneurs who are educating others. Just remember that whatever you put out there on YouTube, whatever you share your prompts, you share your workflows. It's not a trade. You cannot claim it as a trade secret. You release it out there, it's not a trade secret anymore. So lastly, the last bigger topic that we are going to cover are licensing models. IP, in the beginning, I said, why is IP important? IP is important because it is an asset for your business. Again, any venture capitalists or private equity or other companies that might be acquiring your company, they will want to know what you own in terms of IP, because a lot of the value will be in the IP. And for a lifestyle family business, again, your IP is still very important because you don't want somebody to basically steal your business and put you out of business. But you usually you don't sell your IP unless you have a big exit and like sell your whole company. Usually you license your IP, and control is key here. And some of the things to understand is when so you are licensing somebody else's IP probably, but then when you build something, you license your IP to others. So there's that two parts to it. So right now I'm talking about you with your intellectual property. If you create some kind of software or workflow and you are selling that to clients, so you will license it to them. Most likely, you're selling your services, but you will license the IP. And some of the things to really understand, are you licensing it to them, to your clients and customers, for their internal use or for commercial use? And so if you say that it is for internal use, then it has to stay within that person or within that business. They cannot resell it. If you give them a commercial use license, you would allow them to resell it. So for example, go high level, right? You can use it yourself, but you can white label and resell it. So that's an example of having a license to resell to others. So you have to think about your product. What kind of product are you building? Is it going to be internal use, or is it going to be commercial use where you allow resale? Another one, when you're building a product or some kind of service for clients and you're licensing your IP to them, is it going to be personal? Is it going to be single user, or is it going to be entity wide? And I think we all know you buy some kind of software, right? Software as a service, and then it's $10 per user per month, right? So you're buying it per user. And if your business has, 2, 3 users, you have to pay for each user separately. So that's single user versus business. And you might have like enterprise level, and they tell you to call us for enterprise level pricing. So they might give you a license for your entire business. And if you have a big business with 150 employees, you might negotiate a business license for your entire business and not on a per user basis. Another thing, when you're selling your licensing your IP, what is the time frame on that? Is it time limited? For example, 1 year, or is it single use? So again, we often see with things like SaaS, it's month to month, right? Or it can be you buy it for a year. A year term is pretty common for time. And these terms need to be clearly defined in your customer services agreement or your client services agreement, your terms of service, you might call them terms of use, terms and conditions. And again, I'm working on putting the client services agreement and the terms of service as templates under businessattorney.ai, specifically geared towards AI entrepreneurs. So you guys can come and use those templates and know that they were, created by an attorney specifically for an AI business and not just something generic or AI created. So this is on the licensing model. This is your IP and you're licensing it to your customers or clients. Now we're going to talk about open source and AI tools which you're using. You're using somebody else's software, and what kind of terms do they give to you from their IP to what you can do with it. And so we have to be very careful as AI business owners with the tools we use and whether they're open source or proprietary. So open source tools are common in the AI world, but they are risky, and you have to know what kind of license they give to you. And there are several different ones. There's the MIT Apache, which usually is a permissive license. So it usually tells that you can use their software, their IP, their product. They usually require attribution, that you attribute it to them, but you can use it, you can resell it. There is another open source license called GPL, and that's viral obligations. And so because it's open source, if you have something you're using with a GPL license, they actually can force you to open source your code. So this is way more risky. So you have to be very careful. Whenever you're using the tools, other tools, you need to understand what kind of license they give to you. For most SaaS and different APIs, these are proprietary licenses. They're not open source, they're proprietary, right? So you actually have to know what they say, read their terms, understand their terms. And the most important thing here is track all usage. And this is hard for so many people, tracking things, right? There's some people who are so good at tracking, but most people, and I would even put myself in many cases, tracking is not a strong point. But if you can't do it yourself, if it's too, not your personality, hire somebody who can help you track. And so here I will show you what should you have. You should have a license tracking spreadsheet. If you are, an AI business, you should have something like this. And here's a sample. You want to, list all of the components or tools that are using. You want to make sure you know what license type it is. What are the key obligations that you have? And if you have like internal notes, just something to help you remember. So for example, N8N, super popular out there in the AI world. You probably have all heard it, maybe used it. I've played with it. I spent several days just digging into N8N so I could understand it. So as an attorney, I can intelligently discuss that with AI founders. So N8N, if you're using it self-hosted, the license type is a sustainable use license. And the key obligation is that the attribution is required. And then there's a big restriction. You cannot offer a competing commercial service using their code. So understand that. And then for internal notes, I just put permissive for internal use and building client solutions. And as long as we're not creating a competing SaaS to N8N. So another one that's very popular is make.com, and another one is Zapier. So again, lots of AI entrepreneurs use them. Again, the license type for that's a SaaS. They have their own proprietary license, so you actually need to understand their terms of service. And most of them have the terms of service on their website, so it's not hard to find. You can take it, you can use AI to help you understand it if you need to, but you need to understand it. And so we want to track what are your key obligations if you use make.com or Zapier. You would have no rights to the underlying platform code, not surprising, and there's some data ownership policies that apply. And so for internal notes, I just wrote that we are licensees, we're not owners, and workflows built are our IP, but the platform is theirs. So I would recommend that all of you start having this license tracking spreadsheet in your AI business. Because again, if you're having a big exit or bringing venture capital on board or selling to private equity, they would want to know in their due diligence process, they would want to understand what software you're licensing and if you're using it properly, in addition to what your product is and how you're licensing it to others. So here, how to license your AI product to others. The fundamental principle here, because you want to monetize what you're building and you license it. You don't sell it outright unless you have like an exit, right? You license it, and control is very important. The core principle here is define your terms in writing. If you're reading terms of service from all of these other big companies, right, you want to have terms of service that protect you and describe how your license is to be used. Always define these terms clearly, written agreement, and these terms are your levers. You get leverage for your pricing. And you can have product tiers as well, depending on what kind of license they get. Like I was saying, if you have per person per month, or you can negotiate enterprise level, something like that. The key levels for your licensing model is the scope of use. Again, is this an internal business license or is this commercial? Can they resell it or not? What is the user base? This is if it's per user or if it's some kind of enterprise level, duration and frequency. Again, if there is some kind of time limit or what is it, month, year per project. So again, very important to have that in writing. Common pitfalls. This is just we're getting to the end of our time, and these are common pitfalls for all of the IP we've discussed, not for any particular one. Again, just to reiterate what we already talked about, you have contractors without IP assignments. Common pitfall. Fix it. If you don't have it initially in your independent contractor agreement, you can fix that with a standalone IP assignment agreement. Later on, just make sure that it's retroactive and proactive, covers the past, covers the future. Even though that is not one of the 5 core templates I'm pushing out first, it will be something else that we offer eventually. Domain name mistaken for trademark. Don't, again, hopefully that I made it clear your domain name is not a trademark. Make sure with your open source that there's no misuse. You understand what license you get from your tools and comply with that. Make sure you put copyright notices. Just do the little C, year, and who owns it. Not hard, but it's good to have good practice. And then for your business, when you're getting your legal, getting your contracts, just remember that AI generated templates are not the same as having an attorney work with you. Kind of the step gap there are attorney drafted templates, and then of course hiring an attorney for custom work is really truly best. But for AI entrepreneurs in the early stages, that might be too expensive. That's why attorney drafted templates are a great solution. What are the action steps and the roadmap? I would recommend that you run a clearance search with trademarks. I mentioned that there are free searches out there. There are paid ones as well. Make sure you add IP clauses to your contracts, the IP assignment clauses. Add copyright notices on your website, on your whatever other materials you have. Track your licenses, like we talked about. Another step really is important. We're back to kind of tracking. To have an IP inventory of your business. Sit down, create a spreadsheet. Again, I will have this resource available. Very simple. Have your asset, IP asset, what it is. We talked about, trademarks, copyrights, trade secrets. Again, copyright. Here's domain name, trade secret, copyright. And so describe what it is, which one of the types it is, who created it. Was it created by you personally? Was it created through your business entity, LLC, corporation? Was it created by an independent contractor? Who owns it? Really think about it. Who owns it? If you don't have any assignment clauses already, your independent contractor might own it. What is the proof of ownership? It might be not applicable. But it's good to have that. It's either the original document or this follow-up IP assignment agreement. If it is registered, have some kind of information here, key dates, and then notes of some sort where it's stored and locating. So I think if nothing else, get your IP inventory started, get your licensing, license tracking started. And lastly, I would, again, invite all of you to come to our school community called Legal Launchpad. That is where you can find me basically on a daily basis. Post your questions there. I share all kinds of resources there. It's a free community. So again, it's on school.com, Legal Launchpad. You can search for that. And I would invite you all to do this legal risk report. It is something that I created. It is a very quick online intake. You can see the link at the bottom. Online intake form takes under 15 minutes. You get an instant report back. It's based on the legal protection system that I displayed at the beginning with the 5 pillars. It is attorney created. I created the report. It is not AI generated. It is automated in a way that based on your answers, you will see different report writing, but I created it. And it has actionable steps for you and solution. It has links to resources. And optionally, as part of that, you can schedule a one-on-one call, discovery call with me. We'll go over your report and see how else I can help you, we can help you. And again, the link for that is on the bottom of the screen. And I will stop sharing, and here I can see the chat.